and I quote, "Folks be dropping like flies," is what he said. So I won't be coming out of my mouth.
That works.
Okay, still waiting for one more connection.
Oh yeah, that's my client, Todd Schaefer. He's the member of LEGC. He's not
All right, Shannon,
sorry.
you can put us on the record.
Good morning, Your Honor.
This
Mohammed.
is a matter of KG versus Jackson Property Partners. Counsel, go ahead and enter your appearances.
Thank you, Your Honor. Mohammed Nimi on behalf of the plaintiff, Martin Kaji.
Kenneth Beams on behalf of LEC.
Eric White on behalf of Jackson Property Partners and Robert Sales.
BEAMS. Okay, I'll hold off until Todd makes his audio connection. Okay, he's in. All right, I know there are mirror image motions for summary disposition. I don't know who filed first. I don't know that it really matters. Why don't I hear from plaintiff first?
Thank you, Your Honor. Just to go over some of the facts briefly, on December 15, 2016, the defendant Jackson Property Partners, through its owner, Robert Sales, entered into a purchase agreement with non-party Ricky Manjo for the purchase of two properties, both in Jackson, Michigan. The closing under the original purchase agreement was extended 4 times by the parties. Jackson Property Partners affirmed in its deposition that all extensions were valid and timely. The fourth and final amendment to the purchase agreement assigned Mr. Manjo's interest in the purchase agreement to the plaintiff, Martin Kaji. Jackson Property Partners admitted that this was a valid assignment. And pursuant to the final amendment, the parties were supposed to close by January 11, 2019. Jackson Property Partners admits in his deposition that no event occurred to change the fact that the parties were already closed by then. In fact, defendant LEGC admitted in its response to our motion that on its review of our property partners, it too believed that pursuant to the terms of the agreement, we were still under contract to purchase the property. The plaintiff and Jackson Property Partners were set to close on January 9th, 2009. As that closing date drew near, plaintiff attempted to contact Mr. Sales on numerous occasions to confirm that he would be appearing at the closing. Mr. Sales never responded to either the plaintiff's then counsel, or the title company. Plaintiff's attorneys sent JPP emails on January 2nd, 3rd, 4th, 6th, 7th, 8th, and 9th in order to confirm that Jackson Property Partners was going to attend the closing. They refused to respond. The title company reached out to Mr. Sales on the 7th, 8th, and 9th. They refused to respond to them as well. We did everything in our power in order to close by the 9th. No part of that. The owner of the title company, Ellison, signed an affidavit that's attached to a motion. The plaintiff was attempting to...
Counsel, let me stop you for a minute. You're coming through kind of choppy. Do you mind if I reach you on the court conference phone? You can leave the image open, turn your audio off on your computer, and let's see if we can't get a little better sound through, okay?
No problem.
Give me the phone number, please.
Sure. 313-414-4004.
Middle 3 digits are 414.
Yes.
All right, I'm dialing now.
Hello?
Okay, that sounds much better.
Very good. Now, Your Honor, was there any part that you didn't hear that you want me to go over again?
I know. I read your briefs, so I'm familiar with the facts. The minor times when your voice clipped, I heard enough to remember that I read the points in your brief, so just, you may
Very good.
continue.
Thank you. So the owner of the title company, Mr. Ron Ellison, signed an affidavit that plaintiff was attempting to close, but that Jackson Property Partners refused to respond to confirm that it will appear. Come to find out, Jackson Property Partners entered into a different purchase agreement with defendant LEGC on November 15th, 2018 to sell the very same property. Now, the defendants are using two justifications to why they didn't close. Number one, they're saying that plaintiff didn't have the money, which is a brand new argument and completely frivolous, and I'll explain why. And number two is that plaintiff did not want to close, which again goes against all the evidence in the record. The party signed a protective order that was filed with this court, and under the protection of that order, plaintiff provided his bank statements and the bank statements of his financier, Jason Brico. The plaintiff's bank statements showed that he had over $400,000 in cash, and Mr. Brico had well over $300,000 that he was going to be financing for the property. Mr. Brico signed an affidavit saying that he was ready, willing, and able to loan plaintiff the money to purchase the property. We sent that to the defendants on December 20th. I have the copy of the email right in front of me if you want to see it. They knew that they had the money, and there's no dispute about that. The purchase price was $550. There was over $700,000 in worth of money to pay for that property. Now, in a desperate attempt to create any genuine issue of material fact, LEGC claims that the plaintiff did not know during his deposition Mr. Brico's home address when asked. And based off of that alone, they're saying that the affidavit is suspect. Of course, we don't need to know Mr. Brico's home address. Mr. Brico provided his bank statement that they have a copy of and signed the affidavit. So both of those arguments are frivolous. Next, LEGC argues that plaintiff did not want to close. Attaches Exhibit G, and throughout our brief, we cite over 11 emails trying to confirm the closing date with Jackson Property Partners. In each one, plaintiff through its counsel is repeating that they are ready to close, and all they need is Mr. Sales' confirmation that he'll be attending. Again, the title company even signed an affidavit to that effect, that he was refusing to respond to them. Then LEGC responds to our motion by absurdly claiming that Sales wanted to close. And this is completely contrary to Sales' own testimony. Sales testified that, although erroneously, he believed that the agreement automatically terminated sometime in November 2018 because the plaintiff did not affirm acceptance of the property, whatever that means. Of course, the contract states that the plaintiff is only required to notify seller if the plaintiff wants to terminate the agreement. This alone, the testimony alone from Jackson Property Partners, is enough to show that he had no willingness to close with the plaintiff. There is no genuine issue of material fact that he led everybody to believe he wasn't going to be closing. And this is very important to our argument for specific performance, which I'm going to get into right now. But Your Honor, before I get into that, I would like to make a request to this court that they preclude LEGC from arguing any point in favor or against specific performance, as they have no standing to argue it, and they weren't a party to that contract. You can make a decision whenever you feel like it, but I'm going to continue with my argument until you direct me to stop.
Keep going.
So the plaintiff is entitled to specific performance for two reasons. The first one is that it's entitled to specific performance based on the contractual remedies, not just equitable remedies. So the contract itself provides for a remedy in the event of the seller's default. If you look at paragraph 11, it states that in the event of a default by seller hereunder, purchaser may 1, demand and be entitled to immediate refund of its deposit and full termination of this agreement, or 2, enforce the terms of this agreement by specific performance, and seller agrees that the purchaser shall be entitled to such remedy. Jackson Property Partners agreed in writing that plaintiff is entitled to specific performance upon seller's default. No other requirement is made for the plaintiff to be entitled to this to specific performance other than seller's default, and that includes tendering of money to escrow. Now, Sales admitted in his deposition that nothing in the purchase agreement requires plaintiff to tender performance as a prerequisite to specific performance. So the court cannot read any other condition into plaintiff's right to specific performance. Defendant LEGC in their brief will argue that the specific performance is an equitable remedy. And they cite the case law that permits the court to enforce a contract And the terms that were used, the language that was used is when plaintiff does not otherwise have an adequate remedy at law. But here, in this case, plaintiff has an adequate remedy. The plaintiff has a contractual remedy to specific performance in the event of the seller's default. And it's very clear to everybody here that Jackson Property Partners defaulted by refusing to close. The party scheduled closing for January 9th. There's emails that we went over 11 emails trying to get his consent to close, and he responded to all of them. JPP failed to respond to our request, title company's request. They failed to close. They defaulted, and thereby entitling plaintiff to specific performance, plain and simple. We cite a case, Your Honor, called Main Street Dining LLC versus Citizens First Savings Bank. And in that case, the trial court held and the Michigan Court of Appeals affirmed that a plaintiff is entitled to the contract's clear language as the party's remedies upon default. And that's what we had here. We had a clear remedy of specific performance that JPP agreed to. Our second basis for specific performance is based off of the requirement to tender full payment. So the defendants argue that we're not entitled to specific performance because we have the tender performance, we have tender payment first. Well, Michigan case law is very clear that a party is not required to tender performance in order to be entitled to specific performance where payment would be futile. The defendants concede this in their response that that's the law in Michigan. They claim that it wouldn't be futile because Jackson Property Partners tried to close. Of course, this is absolutely absurd considering that Robert Sales himself testified that he never intended to close because he believed he had no obligation to close. And he admits to intentionally ignoring the emails to confirm closing. Now, we contacted him on the January 2nd, 3rd, 4th, 6th, 7th, 8th, and 9th, like we talked about earlier. He failed to respond. The title company reached out to him 3 times. He refused to respond. They refused to respond to 9 emails, several phone calls, and made it obvious to everybody, including the title company, who signed the affidavit saying the same thing, that they would not be appearing to close. Clearly and undisputably, it would have been futile for the plaintiff to tender performance where the defendant wouldn't show up. So on that basis, Your Honor, and pursuant to the extensive supporting case law in Michigan, Jackson Property Partners failed to respond to 9 emails to confirm the closing, his failure to attend the closing, his belief that he didn't have to close, his admission that he ignored communications to confirm closing, the title company's belief that he was evading closing, and his entering into a purchase agreement to sell to a different purchaser, all made it obvious that the tender of performance would have been futile. And therefore, Jackson Property Partners, and in this case, LAGC, cannot use failure to tender as a defense. Jackson Property Partners' failure to close constituted default, and the plaintiff is entitled to specific performance under the agreement. There is no genuine issues of material fact to dispute this otherwise. Now, Your Honor, I can continue to my argument for tortious interference, or I can let defendants respond to that plan.
Let me ask you, if I were to grant your motion and award specific performance, doesn't the interference claim become moot at that point?
I think there possibly could be damages for that. But yeah, I do think there'd be additional damage on top of specific performance.
Well, but you have to establish that the reason the seller breached is because he was induced to do that by a competing offer. Do you have anything other than the fact that there was a competing offer outstanding? I mean, clearly he was aware of the other contract, made his competing offer as what I understood to be a backup offer that he knew if you closed with the primary seller that there wouldn't be any property left for him to buy, correct?
They knew that, yeah.
All right.
That's correct. But now the problem is because of that purchase agreement, that backup purchase agreement, that's what's causing the problems here, because now plaintiff can't close with the defendant, Jackson Property Partners, because of this purchase agreement. And LEGC filed an affidavit of interest on the property to cloud title, and they entered into a lease agreement on the property for the next 5 years after the fact. They indisputably knew that my client was trying to close. So if we get those removed, the affidavit of interest and the lease agreement, we're willing to toss our claim for tortious interference.
Okay, Mr. Beams, you want to go next?
Yeah, sure. Yes, Your Honor. I just wanted to address the tortious interference claim first, since we're just talking about that. I think the undisputed facts in this case are that my client signed the purchase agreement with Jackson Property Partners when he was advised by Jackson Property Partners real estate agent that the initial purchase agreement with the plaintiff was expired. So we believe, and so we didn't have knowledge that there was a contract. We were told otherwise by the seller. So, and not only that, they pursued us. Alex Perlos, who was the agent for the Jackson Property Partners, sought out Todd Schaefer of LEGC because and pursued him because they believed that their agreement with the plaintiff was going to expire on November the 12th of 2018.
Was that same realtor involved in the sale that the plaintiff is seeking specific performance of?
No,
No, Your Honor.
no. I think, my understanding is Bob or Jackson Property Partners retained Alex because he thought that they were not going to close. And he, I believe, reasonably believed that after 4 previous extensions on their due diligence period, he obviously got very concerned about the situation. And again, they believed, not my client, the seller believed that it terminated. We relied on their statements when we entered into the purchase agreement. In hindsight, we would not have signed this thing had we known what was going on. But regardless, that's all 2020 vision.
So from your client's perspective, this was not a backup offer. It was the other agreement had expired, or did they even know about another agreement?
We were told that there was a prior agreement and that the seller believed he was not going to close by November the 12th, which they told us was the deadline. And it was not a backup. It was what we were advised, a new agreement to purchase the property. There was nothing else competing.
Well, let's make sure we're not quibbling over what a backup offer is.
Right.
At the time that LEGC signed its agreement with the seller, the prior agreement had not yet expired in the seller's mind. Is that right?
No, it was the same day that my client signed it, but it was only in response to an email from Jackson Property Partners agent saying, "Hey, we want to get this signed today. We want to get this tied up ASAP." It was not they pressured my client. Let's get this done now. My client signed it, sent it back to their agent, who then sent it to Jackson Property Partners. They signed it on November the 15th, which was 3 days after we were told the purchase agreement had expired. So the contract that we entered into to purchase it was actually fully executed after we were told the contract had terminated with the plaintiff. And then we go down, we did all the due diligence to close. We were ready to close. And the first week of January, stuff hit the fan. The plaintiff came out of the woodwork, contacted Bob of Jackson Property Partners, Bob Sales, who then told us about it. And he again told us, "Hey, I'm not under contract with these people. Don't worry about it." And they're not looking to close. And our response was, let's see the proof. because this is, we wanted to be careful. We did not want to get into a lawsuit, which we did anyway, but we're trying to avoid getting sued, closing on a piece of real estate and then get sued over it subsequently. We looked at the purchase agreement and all the addendums, and we believe, based on what we saw, that in fact the contract had not terminated, that they did have a right to close as of January 11th, up to January 11th, 2019. We advised Bob of Jackson Property Partners, we're going to stand down. You go ahead and close with these guys if you, or you do what you're going to do, but we're not closing with you until this thing expires because we're not going to get sued. We insisted that Bob go ahead and close, or set up a closing at least, because Bob was telling us at the same time he didn't believe that they could close. He didn't believe they had the money, and in fact, testimony during this time showed that they were not looking to close. The plaintiff was not looking to close during this period of time. They met with Bob at the building on January 7th, not looking to close, but looking for another extension and to do a lease instead of closing on the purchase agreement. They followed that up with an email to Bob, which is all attached to the motion in our response, saying, here's the proposed extension, while we work out the terms of a lease. It was only when Bob rejected these things and said, no, I want to close. And then he contacted the title company looking with the schedule of closing with the title company. This all happened in a very short amount of time, but during this period of time, we were standing down. We're not looking to close. We said, it looks like you're under contract with these guys. Do what you got to do. We're not gonna get involved. In fact, we also insisted that he schedule closing, and whatever happens, was our position. We in no way, we did not sign the contract, or we didn't induce this breach. And when we found out about it, we backed down. There is no basis for a tortious interference of anything here. If anything, we acted in good faith throughout. So I think based on all those facts, there's no reason to, whether regardless what you do with the specific performance, which is a lot trickier, there's clearly no issue of fact with respect to this claim. It should be dismissed. With respect to the specific performance, we briefed that issue we briefed it. And I know you've read it. I think the high points are, again, the tender issue. They say that Bob or Jackson Property Partners essentially was not going to close, and that it would have been futile to try and tender. That's just not the case, Your Honor, because they may have been they were sending emails to the title companies with schedule a closing on the 9th. We've got the money, but they never ever produced anything that showed they actually had the money. But all the while that's going on, at the same time, they're going to Bob personally saying, let's extend the time under due diligence. Let's do a lease instead. Why? Because they didn't have the money.
Hold on a minute. You
Sure.
said something to counsel for plaintiff indicates that you've been provided with financial statements and bank records showing that sufficient cash was indeed available to close. Do you have any evidence to the contrary?
I have bank statements. I did not of the plaintiff showing that he was short. I don't have anything from the so-called lender, and which is why I don't have any documents from him. Well, I saw the affidavit attached to their brief. That's the first I saw of anything.
I thought I heard plaintiff's counsel indicate that he had bank statements from that lender to show that he had sufficient money.
I don't recall.
That's correct, Your Honor.
Getting those, Your Honor.
Yeah.
Maybe I have them. I don't recall seeing them. They were produced months ago. Again, I don't recall seeing them. And certainly the affidavit was the first I saw that he supposedly was going to, I know they talked about making a loan in his deposition. I asked him specific details regarding this loan, and he didn't have any detail regarding, it was just a handshake deal. It was nothing was in writing. He didn't know where he lived. He didn't know how he was going to pay it back. It's highly suspect that this was actually going to happen, especially in light of the fact that the purpose of this building for the plaintiff was to be for a medical marijuana provisioning center. And he hadn't got his license approved yet. And in fact, a month and a half later, he got it denied. And as far as I know, it's still denied to this date. It's highly suspect that which goes into why they were trying to get more time to close on this building. They didn't want to buy it. He wanted more time to see if he's going to get his license. And he testified to that. He testified in his deposition. I asked him numerous times in his deposition, you had 4 opportunities to close, and instead you kept getting extensions on the due diligence. Why? And he's basically testified, why do today what I can do tomorrow?
So how is attempting to get an extension inconsistent with, how is attempting to get an extension inconsistent with also attempting to close at the same time?
It's not if you don't really intend to close, or if you do intend to close. I've seen emails from the lawyers saying we have the money and we want to close. I haven't seen any official documents saying anything that says he actually did it. And when push came to shove, he didn't actually wire anything to the title company. They had the closing statement amount from the title company saying how much they needed to close, and nothing was wired. Bob followed up with the title company, talked to Denise Ellison. We produced or attached the emails to get this thing pushed to closing. They had plenty of time to do this, and nothing happened.
Your Honor, may I respond to that?
And again,
In time, I want to hear him finish.
so is it inconsistent? Look, it depends. It depends. What I can say is when they've had other opportunities to close in the past, they didn't. They instead asked for more time. They had 4 different extensions. Prior to this, they had been to January of 2019. They had more than 2 years to close. Abel, can you hear me okay, Your Honor?
Yeah, it came through.
Okay. So he had over 2 years to close. He wanted more time. I mean, is it inconsistent? I think it is, especially when you're telling the title company unequivocally, we want to close on the 9th, and then you're meeting with Bob in person saying, we really don't want to close on the 9th. Please sign this thing. They were pressuring him to sign the extension in person. So, I mean, we think, again, he didn't have the money to close, and he didn't want to close because of the licensing issue. That's been consistent throughout.
Okay, thank you, counsel.
Thank you,
Mr. White? You need to unmute.
Your Honor, I think that Exhibit 2 and Exhibit 3 essentially thwart the plaintiff's motion for summary disposition. The plaintiff says Bob Sales did nothing. Take a look at Exhibit 2 and 3. There's emails from Bob Sales to American Title. Clearly.
Hold on a minute. Hold on, I don't have these tabbed, so I want to make sure I'm looking at, okay, Exhibit 2.
It's going to be Exhibit 3, Your Honor.
All right, hold on. I'm looking at the first page of Exhibit 2. This was an email to Tara Kellerman at Jackson American Title Company of Jackson?
It is, Your Honor. These are all emails from my client to American Title, and the plaintiff makes it sound like that my client just simply disappeared. This whole series of emails essentially guts their summary disposition motion. It
All
clearly
right, well, hold on. So the representation that your client went silent and ignored all invitations from American Title Company regarding preparing for a closing are
False.
inaccurate.
Absolutely false, Your Honor. Let me quote the one. Denise, I guess if you want to get a payoff from Old National, you can. Clearly, he's saying get a payoff. There's a whole series of emails here. It's rather baffling that they would simply claim that he ignored them. The other thing, besides that, that guts their motion completely. Look at the email exactly, Your Honor, that was sent requesting the extension. I believe it's this would be my exhibit 2. Actually, there's an email from an attorney dated January 4th. Happy New Year. Please see the attached proposed Fifth Amendment to purchase agreement for 3481 page. We are prepared to deliver the $25,000 extension fee you mentioned in your prior email. Please review at your convenience and let me know if you have any other questions. If all is good, please have this signed and sent back. You notice there's nothing in here that says, hey, Bob, we've been trying to get a hold of you to close, because if you listen to the plaintiff, they say 2nd, 3rd, 4th of January, Bob does nothing. And then you have a January 4th email from that very attorney who doesn't say anything about, hey, Bob, you've ignored us. It says Happy New Year. Here's the amendment. It's completely inconsistent with their ability to close. Our Exhibit 2 and our Exhibit 3 just simply guts their argument.
Well, I don't follow the argument that just because they asked for an extension, that means they will not or cannot close on the deadline for closing. I mean, that's not uncommon. You're heading up on a closing deadline. You want more time, you ask for it, but if you don't get it, you still go ahead and do what you need to do so you don't lose the contract. So help me understand how that's inconsistent.
It's very inconsistent. Think about it. The plaintiff claims starting January 2nd, they're desperately trying to get a hold of Bob Sales from Jackson Property Partners, and that Bob ignores them. That is clearly a fabrication. Look at this email. Happy New Year. It doesn't say anything about we're running up against time limits. Let's do this instead of closing. It never mentions a single word about any closing in there whatsoever, that a date's coming up. It just says, we need a 5th extension. We're going to give you the 25 grand. It's the lack of any reference that we want to close that really shed some serious credibility issues. That's
Your
why.
Honor, obviously he's looking at only one.
All right, but I'm just having trouble finding that particular. That's not part of Exhibit 2
It is.
or Exhibit 3. I mean, I thought Exhibit 2 was.
Your Honor, Exhibit 2 is the Fifth Amendment that was prepared by plaintiff's previous attorney, as well as an email on January 4th from Joey Kedgeboo, who was an attorney, to Bob Sales, that starts out Happy New Year. It doesn't start out, hey, we've been trying to get a hold of you. The tone of that email doesn't lend any indication that they have that they want to close. Nothing in that email mentions closing or Bob's inability to communicate with them. It completely flies in the face of what they're saying.
I thought the allegation as to the lack of responsiveness was after this date.
Well,
No,
that
the
doesn't work either.
allegation. Yeah, that's right. That's right, Your Honor. It was after that. And if you look at Exhibit G, I'm sorry, the one that Mr. Beams referred to and conveniently left out significant portions of it. It's an email from Mr. Cashbo to Bob, Mr. Sales, and he says, I have attached a proposed extension that pushes back our window to February 1st, 2019 to work out any remaining issues. Then he continues to say, it is imperative that we get to sign today because at this time we are prepared to close tomorrow. And we have been in contact with the title company since last week to coordinate a closing. I would like to give them some professional courtesy and adequate notice of how we are proceeding. So just like you said, Your Honor, what they're trying to do, they're trying to work out an extension, but at the same time, they're telling us, listen, we're ready to proceed with closing. Nothing they can say goes against that. And, Mr. White pointing to one email where he doesn't push him to respond, it's a red herring.
Your
Because
Honor,
the title company is requesting.
All right, I follow your argument, counsel. Let Mr. White finish his argument.
So just assume, Your Honor, that they're not inconsistent. The fact that there's those emails between JPP and the title company about the closing, that totally guts their motion for summary disposition. They say Bob disappeared and did nothing. I've attached a number of emails and Bob's affidavit that fly in the face of that. Therefore, C10 doesn't work. There's a dispute as to a material fact. They must lose as a matter of law. Thank you.
Thank you. Okay. And I'm sorry, counsel, how do you pronounce your last name?
Nimi.
Nimi?
Yes.
Okay. You get the last word.
Thank you, Your Honor. Well, first of all, none of those emails that were introduced by Mr. White in his motion were ever produced in discovery. As a matter of fact, during Mr. Sales' deposition, he produced 4 emails only, none of which had anything to do with contacting the title company. I asked him if he had anything else. He said he had nothing else, even though I knew there was more because LEGC was producing communications between Mr. Sales and the title company that they weren't even involved in. So I know they were coordinating something between each other. But if we look at there was an email that was attached by LEGC dated January 9th, 2019 at 2:10. This is apparently Bob contacting Mrs. Denise Ellison of the title company. And he responds by saying, this is the day they're supposed to close, by the way. I guess if you want to get a payoff from Old National, you can, because at this point there was mortgages on the property and they couldn't close because there was mortgages there that called the title. Then he continues by saying, well, then if they can't get it to us fast enough, at least we tried. Then the title company responds by saying, sorry, I can't request anything. I don't have any any authorization or account information. So at this point, Mr. Sales is pretending like, okay, fine, you can close, you have to do 1, 2, 3, and you can close. Well, the title company had no ability to garner any of the mortgages that were outstanding because he didn't provide us with any information. So under no circumstances could we have closed. When it comes to the testimony that LEGC put forth regarding that we didn't show them how much money we had or prove that we had the funds, that's erroneous. We had no obligation to count cash in front of them to show them that we had an adequate amount. They knew through the deposition of Mr. Kaji how much money he had in his bank account. They knew he was getting financed by Jason Brico. We submitted a witness list that identified Jason Brico as the financier that was going to front $300,000 for the right. So they knew all of it. They chose not to depose him, and now they want to pretend like they didn't see anything. They had no idea that he had the money available. But he did. He was trying to close. Every single email here shows that he was trying to close. There's not a single email where it can point in any respect that the plaintiff didn't want to close. Yeah, he was trying to work out an extension. So what? He was also trying to close. And every time he said, I want an extension, he also followed up with, we are ready to close. That doesn't defeat our motion for summary disposition. It enhances it. It shows that they have nothing else to defeat it. There's literally no genuine issue of material fact on the claim for specific performance.
All right, council, I want to take some time to go back and look at all of these attachments. I had a little different understanding of what the exchange was from the briefs than what I'm seeing in these attachments. I want to look at them. And I'll issue a written decision.
Thank you, Your Honor.
Thank you very much, Your Honor.
Thank you.
Thank you.
You can see him, Howard.
Have a good day,
Good day,
gentlemen.
everybody.
Yes.